do you think the judge was showing good concern or that he was being overzealous?
No, I think it was just in the interest of justice. He's one of the judge that when you go, you'll see that he's very hard when it comes to the issue of state prosecutors and the investigators, because he thinks that the attitude of investigators and state prosecutors that when they come, they don't take the job so seriously that they want to prosecute. And even in this case, what makes the case very interesting was that she was granted bail. And every judge who is concerned would want to know that what is the nature of this case? What are the facts that a narcotic case or cases that are not bailable, the person has been granted bail. And from the record, when this person was granted bail, that was the end of the matter. The case had died naturally. So it was the passion or the curiosity to find out what exactly. It was within this period that he even found out that the surety even had to be put in. He issued a bench warrant on his own. There was no, the normal procedure is a forfeiture to be brought by the police, the investigator. This was not done. So it was the judge who issued bench warrant for the surety to be, and the surety was in jail for 4 months. It was after the surety was there that the woman had to be brought in. So if the surety had not been put in jail, that would have been the end of this matter. So I think the nature of the case itself, and there were eyebrows, people will raise eyebrows that why this is a case. We should put it on record also that he said it categorically, he was not the one who granted bail. The bail was granted in the High Court. He did not do it. And that was when he started and said, I will try this case. And the woman was brought back after 4 months. So it is...
Is it that the woman was lured back or was brought back? Because there are also questions about how anyone was able to convince this lady to return from the U.S. back to the jurisdiction.
Yes, I think the last time I said that, I got to court one day. I was rushing to his court, and I met the surety, who was then in custody. And he approached me too. So I asked him, I held a brief. I said, I was going to defend this man. But when he told me the conditions for the bail...
I've just been prompted that you have to explain surety.
Oh, surety
I'm not making any assumptions anymore.
Surety just means that a person who comes to the court or the police and says that I want to bail this person, it means that there is a contract between you and the state that if I don't produce this person, I'll carry his burden, anything that they say. Right. So that's the person. So the person who bailed her and she went to the U.S. was the one who was put in, and he approached me. Okay. And I asked him, are you sure you don't know anything about this? And he said, oh yeah, I don't know, because they were my family friends. I was just called and I went in. And I told him, no, you can't do this. Narcotics, you must make sure the woman comes back. If not, you would go in for life. That's what I told him. And I left. I said, I couldn't do the case. Okay. So it was out of this that when the woman came. Now, listening to the judge also and the defense counsel, it would seem as if the police, you see, my difficulty with this is that the next day that it was brought, because he has made a clear distinction here. What does the judge do? He has two functions here, administrative and a legal function. Legal is to preside over the court and rule. The administrative is where the exhibits, any other thing is kept. So if we mix these two functions, which are interwoven or overlap, that's where we are getting the problem. And I think that's one area we need to clearly define.
But for you, as you're saying, the judge did the right thing, all in the interest of justice.
In the interest of justice, because cocaine, the drug issue was becoming one of the albatross hanging on the neck of this nation, and everybody was crying. And this was one case people had always been following, because this case took 3 years. People were following it silently to see what will
Let's
have
talk
happened.
about testing and retesting. And I've had quite a bit of discussion about it and people asking all manner of questions. What is it that happened regarding testing and retesting of the substance?
All right, if I can briefly, comment on the aspect about the judge's own intervention towards the resumption of the matter and the prosecution thereon.
Right.
It is true that is his attitude. He's known to be an activist judge. He's known to be very active in what he does. And like he has said himself today, that his major interest was to ensure that justice was done in a matter of the serious nature like narcotics. But the police have their version that it is not really he, the judge, who propelled the wheel that fast, and that they used their own means to use the shorty as a decoy to get Nana Ama Martin into the jurisdiction. That apart,
how did that work?
You just mentioned.
How did that work out?
We have not been told about the details.
Yeah, because that's a very interesting aspect.
Because Joseph Owusu, the investigator who subsequently took over the matter until it was brought to an end, tells us this story, but doesn't give us more meat into it. And you just mentioned that this is a judge who inherited 700 cases. How his eye picked out that case of Nana Ama Martin and gave it that, emphasis. The people who may also read their own meaning into that. But how? 700? There must have been some motivation that got you to see this particular case. But for now, as it stands, we'll go by his testimony. He says that his motivation was to do justice to the Republic. Now, you talk about the call for testing, retesting. You would discover today that between the judge and also defense counsel, Kwabla Senanu, Kwabla Senanu tells the committee that he's dealt with narcotic cases. This is not his first time. He takes us to one of the locus classicus that we have on narcotic case trials.
Kwabla Senanu,
yes.
You're referring to defense counsel?
Yes, defense counsel. And he refers us to the Goman case, the very famous Goman case. Sure. And he says that he was in that Goman case. He refers us also to another case, the Jewel. And he says in all these cases, what he has come to learn is that as defense counsel in a narcotics case, you need to be on the watch. You don't have to blink an eye. And so when he was coming in and knew that police were bringing this for to tender in as evidence, and he discovered that when Nana Ama was arrested, she was not arrested alone. There was another man with her who absconded, and police tried to get her. They couldn't get him. And that there were 2 bags, and these 2 bags, Nana Ama was made to carry the 2 bags to the police station, and the 2 bags were searched, and the slab of cocaine was found.
One slab?
Yes, was found. He is not sure that in all that process, you can say for a fact. In fact, he says that that bag, he believes, belongs to the gentleman who ran away and not Nana Ama. So there's a question there. And then further, we had the police laboratory scientists, police forensic laboratory analyst, coming in to tell the committee today that it is not the case that the substance that was brought, the sample that was brought for testing, was brought together with a number of people, including Nana Ama, but that it was submitted by one individual. After the testing was done, it was returned to one individual. So the questions that are being asked are, she was not there anyway. What is the guarantee that what you did and tested positive was the same thing that was returned to the court on the 27th of September 2011? That question was put to the lab analyst, and he said, I cannot say for a fact that what the police brought to the court and tendered in as evidence on the 27th of September was what I tested positive as cocaine. So you see holes that are being punched in here. And now Kwabla says that, you know what? So you did the testing in your own laboratory. The police arrested the woman, went to their own laboratory to do the testing. He says, this is self-serving. I think that it is important to bring in a third party. So, apart from the fact that when they broke the seals and opened it in court, and he having sat in other narcotic cases and knows the smell, he talks about the pungent smell, which he didn't get. Then his suspicion was raised. He said, no. Apart from the fact that this is self-serving, I can't hear that smell. I can't smell it.
What's the essence of a document or evidence being self-serving? Today, let's bring the law down to everybody's doorstep.
Basically, he says self-serving because, you see, this is cocaine because you say it is cocaine.
Yep.
This is cocaine because you say you have tested it and it is cocaine.
Yeah.
We have not had any independent source of the test. Okay. So that is why in the second request, in his request for a second test, he said, let's go and do it in some place other than the police. Okay. So for him, that was important. Here, the judge comes in. Why did you allow a second test after it was tendered in evidence the first day?
Right.
And was not objected to.
Right.
And Kobla tells the committee that on the first day, it is not really the case that I did not raise any issues. I said, let it be admitted for all that it is worth, for whatever it is worth. Meaning he had issues.
Lawyers say that quite often.
Yes, and said also that he would come the next day and do an extensive interrogation of it. So he prompted the court before the next day. And the next day when he urged it on the court, and the defense, the state attorney vehemently opposed to it, he says that he was happy that the judge brought in handy the case of Jackson Smith versus KL.